One of the most rewarding and enlightening experiences of my public health career was my involvement in 2006 in the Sago mine disaster investigation, and some of those family members are here today. I came to understand and appreciate that family member victims can make a meaningful contribution to the accident investigation process. I heard then, and I still hear today, that family members will impede the investigation, that family members have a conflict of interest, or that family members are just too emotional to be useful in fact-finding. My experience tells me that nothing is further from the truth. With Sago, no one paid closer attention to the details, pressed the investigators harder for answers, and raised the bar higher for mine safety reforms. I would relish the opportunity in the question and answer period to respond to Mr. Morikawa's comments about having attorneys representing family members. It's my experience working with the Sago families and other family member victims that inform my views today. OSHA does have a long-standing policy related to victims' families. From my experience, however, the objective of that policy is vague, leading to vastly different experiences among family members depending on the OSHA area office or the state plan. A condolence letter sent to the wife of Ray Gonzalez, for example, was mailed to her in September 2004, after he suffered burns at the BP Texas City facility. Mr. Gonzalez, however, did not die until November 2004. In addition, in the second and third paragraphs of the letter, it does not mention her husband, but a different deceased worker. Gross and insensitive errors such as this do not give families much confidence in the quality of OSHA's accident investigations. In my testimony, I described the experience of Maureen Rivetta, whose husband was killed in September 2009. No widow should feel incompetent for not understanding or comprehending OSHA's procedures. It should be OSHA's duty to make sure that family members understand their procedures, taking into account how shock and grief can affect one's ability to process information. I also heard at last month's hearing the witness representing the Chamber of Commerce asserting that involving family members does not appear to add much value other than to sensationalize. That comment is terribly uninformed, particularly of the reality of what families can offer to investigators. Speak to any of the family members present here today. They will impress you with their knowledge of the factors that contributed or caused their loved one's death, and their suggestions for ways our worker injury and illness prevention system can be improved. PAWA could go further and build on provisions for a family liaison as contained in the Minor Act of 2006. Family liaison requirements must be strengthened and elevated to statutory duties of the agency. Rights for family members and injured workers are too important to be contained in policy. I fully support PAWA's provisions to reform the whistleblower protections in Section 11C of the OSH Act. When I worked at OSHA in the early 1990s, it was apparent to me, a newcomer to the Labor Department, that the 11C program was a stepchild of the agency. The whistleblower witness here today, Mr. Neil Jorgensen, is an excellent example of why individuals should not be held captive because of the Labor Department's failures. Whether the problems at the DOL are resource constraints, lack of interest, litigation anxiety, or their client is a secretary, not the claimant, health and safety whistleblowers must be afforded a private right of action to pursue their case. At one time, I thought that the whistleblower protection functions delegated to OSHA could be at the heart of a health and safety protection system, but I no longer believe that to be the case. The subcommittee should consider a bolder reform to improve protection for whistleblowers. I applaud your efforts, Chairwoman Woolsey, and your leadership on this crucial issue, and I support your proposal from the 110th Congress to create a separate independent agency to administer all federal whistleblower statutes. Vigilant defense of workers who exercise their whistleblower rights, especially issues related to health and safety, is fundamental to an effective occupational injury and illness prevention system. I'm pleased to answer your questions.